I'm Nikki Jovakic from LookUpStrata. I'm having a chat today with Chris Irons from Strata and Will Marquand from Tower Body Corporate about a recent decision concerning smoking in Queensland strata schemes that came from the Office of the Commissioner for Body Corporate and Community Management last week. We're recording this session on the 25th of January 2022. Chris Irons is an expert in the strata sector and well known for his former role as Queensland's Commissioner for Body Corporate and Community Management. Chris is now working as a strata consultant under the banner of Strata Solve, where he helps clients to untangle their strata issues with tailored solutions to dispute resolution, mediation, and more. Will Marquand is the General Manager and Senior Body Corporate Manager of Tower Body Corporate. Previously, he spent 5 years working in the strata industry in New South Wales. Just a quick disclaimer here, apart from being the owner of LookUpStrata, I'm also a Director of Tower Body Corporate. We're talking about the decision that rocked the world of bodies corporate, in Queensland anyway, last week. The scope of this chat is to provide the LookUpStrata audience with a little more information about the decision, why it was successful, and most importantly, what it means for residents in Queensland strata buildings, both the smokers and the non-smokers. We will also talk about what your building or you personally should be doing right now if you're affected by smoking. Chris, if we could start with you to give us an outline of what the decision is and why it's important.
Thanks very much, Nikki. Hello, everybody. Hello, Will. Hello. We won't labour the point too much. I think we might try and get through it as much as we possibly can. But basically, this was a dispute brought by one owner against another owner. So it wasn't the body corporate per se. The one owner alleged that the other owner was a chain smoker and that the smoke from their balcony was constantly wafting into their apartment, causing issues. The parties attended conciliation. In my former office, the Commissioner's office didn't get any agreement out of that, and then it proceeded to adjudication after that. The decision handed down by the adjudicator, and this was just before Christmas last year, was that a hazard was being created by secondhand smoke. And that is significant because as far as the sector in Queensland is aware, that's the first time that hazard has been considered in those terms before. And effectively what that means, isn't it, William, is that, or not even effectively, what happened is that the adjudicator said secondhand smoke is a hazard.
Yeah, exactly. And I guess the next question is why have they chosen that interpretation at this time? Why has this particular case been the trigger for that change from what's gone on in the past? Because I think we all know that there have been multiple, similar cases gone through the courts that have not produced a similar result. So why do you think that we are getting a different approach this time?
Great question, William. That section of the legislation has been there since the legislation was enacted. So it's been there for a couple of decades. So it was open to anybody to really pursue it, but nobody's really done it before. The challenge up to this point, as you would know really well, William, is that people had to try and prove a nuisance when it came to smoking. And the test for that is extremely high, set by the courts. So that's why it hadn't really been successful up until this point. Why has it happened now? That's a really good question. If you wanted to interpret this one way, you would say that the adjudicator has almost taken it upon themselves to make the decision about secondhand smoke in the absence of government doing it. Is that how you looked at it, William?
I don't know if they decided it by themselves. I mean, obviously they in their findings, they cited cases from New South Wales. So they were obviously feeling that there was some kind of wider movement towards this that would give them confidence that they weren't just acting independently. My question is, behind the scenes, do adjudicators talk about this? Do they talk about how cases might be approached? But would there have been any conversation about the difference between, what is a nuisance and what is a hazard? Would there be any agenda?
I think there probably would have been. Don't forget, adjudicators are human; they're not robots. And and like anybody else, they have an interest in seeing things work out in the best possible way. So the question then, would they have sat and discussed and looked for a way to introduce hazard? Quite possibly they would have. It's also quite possible that in this particular, you've also got to look at the particular circumstances of this scenario. In this particular scenario, I think it's worth pointing out that the chain smoker in question, when asked for a submission by the Commissioner's office, effectively said, bylaws don't apply to me, I can do as I please. That's like a red rag to a bull, that kind of statement for a quasi-judicial officer, such as an adjudicator, to have somebody basically thumb their nose at process. That doesn't go down too well, that sort of thing. So I think that's certainly one aspect of it. I think what it definitely shows, though, is that government has not acted upon this issue for quite some time. Will, there's been this big gap about what to do in relation to smoking. The gap has been filled, hasn't it?
Well, I think, you know, if you're part of the anti-smoking brigade, which is the majority of people now in society, you would hope that that's the case. I mean, I suppose what you're saying is if it's just the decision of one person only, the next case, can that be sort of overturned by the next person who might see things differently?
Yes, it can. So that's a really good point, William. The decisions of adjudicators are not technically precedents. So it's not like in the courts where the courts are bound by those decisions. You would hope that other adjudicators would take that on board and keep that in mind and basically look at it as guidance, but they're not bound by it. So you could feasibly have a scenario where the next cab off the rank for smoking tries the same approach, almost an identical set of circumstances, but because there is a slight difference somewhere, somehow, because there are some different circumstances. Don't forget, in this particular one, there was a lot going on behind the scenes with the two people involved. The person who was the smoker said that she couldn't easily get out of the apartment to go outside and smoke because she had a disability. The person making the complaint said they'd tried a lot of things over the years to resolve and hadn't gotten anywhere with it. So it is very possible, Will, the next one that happens, not 100% guaranteed it's going to pan out that way.
Okay, so this isn't a complete green light for sort of anti-smoking legislation in body corporates or something like that, but it's more just a step towards changing the current situation. Is that
it sets a benchmark now? That's basically what it does. So you can, it's roughly the same as pets in Strata in Queensland. So there's no such thing as a law against banning pets in Strata, but everybody knows that the way things have gone, it's highly likely that you can't. So the same thing here. While there is nothing black and white set in concrete that there are no smoking buildings in Queensland any longer, it kind of is like that now.
Yeah. And I think with smoking, we're on fairly safe ground because across society as a whole, I mean, we know that smoking's reaching its end game, essentially. You know, it's slowly being managed out, and it's just a question of time. No one's really, I don't think that's really under dispute anymore about whether smoking's, you know, societally acceptable. It's just a question of how long the remaining smokers continue to do it at and have their rights to do it. So I think most people could feel fairly confident moving forward if they wanted to bring any kind of anti-smoking bylaws into their body corporate, that now's a good time to do it. They've really been given the opportunity to create that chance. Would you say so?
I think so. So the chances there that people did not have previously, I think that's probably the big thing. So people who might have felt frustrated that there were no options to resolve a smoking problem that they had. I know you would get complaints about smoking in your role.
Many complaints, yeah.
The option is now there that was not there previously. So that of itself is a huge change. Let's talk about what are the other aspects of this decision that kind of hasn't gotten the same amount of attention, but is, I think, pretty prominent nonetheless. The adjudicator, William, made some pretty harsh comments about the actions of the committee, didn't they?
Yeah, I mean, I think that they effectively criticised them for being inactive. The committee in this instance had determined that it was a matter left best between the individuals to resolve. Perhaps they might feel justified in that because the individual who brought the action has brought it successfully. So that there's some evidence there that the approach was correct. And yet the adjudicator was pretty strong in their wording and saying that really the body corporate should have been leading this action in, because they should have been the ones protecting the bylaws that they've instituted. Personally, I don't really see it that way. I think there can be lots of different factors as to why a body corporate may or may not participate in any individual action. And I think that the if you don't want to have individuals pursuing cases, then that option shouldn't be available. But because it is open, there's nothing wrong with body corporates choosing that at this stage. But I know you see it a little bit differently, so perhaps you could expand on.
A little bit. I'm certainly really sympathetic to the committee, both in this case and generally. I mean, they're volunteers, Will. It's a hard job being on the committee when you've got people demanding things and complaining and wanting things done all the time. I guess in this case, the way I look at it is that if it had been like a duplex or a really small complex, that might be a slightly different story. But here we're talking about a multi-story resort tower on the Gold Coast. So this is a building that people go to for holidays and would be advertised interstate and overseas. So you're a committee, you've got a building like that with budgets in the millions of dollars. You would have lots of people that you can rely upon for advice, contractors, legal advisors, body corporate managers, the works. If you then became aware that there was a very intense running battle between two people on different floors, and by all accounts, if you look at the order, things were heated for some time, I kind of wondered to myself, why wouldn't you step in and try and do something about that, particularly if you know that if it goes further, then you might actually be up for a fair amount of costs yourself or a fair amount of grief yourself. And this is a really good point to remember, Will, that once an order of an adjudicator is made, it's out there on the public record, and anybody can search for it. So say, for example, you come along and you decide you're interested in buying into that building into the future. During conveyancing, you do your search and you see an order that was made, that might actually entice you to not buy if it's an order that's not in your favour. And in this case as well, now that building's got a reputation as well. So you can see, can't you? And tell me if you think that I'm sort of going a bit too far with this one, but you can see, can't you, when people hear the word Arctic, they might go, oh, hang on, wasn't that building that had that smoking problem back then? Well, I'm not sure I want to go there.
It might trigger a few people's memories, and certainly as people do Google searches in the future, even if they're just looking for accommodation, this case is going to come up. So it's definitely going to be there. Is it enough on its own to affect sales prices at the property? Probably not in my experience, but it's certainly something of consideration. I think part of the problem is, if you're the committee, they would have had a look perhaps at past cases and seen all of these fail time and time again. And when you see that going through the courts, there's not very much encouragement there. Why would they think that they're going to be the ones to necessarily be the game changer in this situation? I'm sure when they had their discussions as a committee 12 months ago, they weren't. That wasn't on the agenda. They obviously didn't know what the outcome was going to be. So they probably couldn't factor that in. And it's pretty hard to expect committees, I think, to expect them to be the ones doing all the hard work to drive these issues change, to drive these kind of, really, this is a change in society when they haven't been receiving the support from the courts over the time, or the indication that they might receive the support. So
I'm actually with you on that one, William. I think that's really hard, that one. I think what it does do is it really highlights how bodies corporate have to act in relation to bylaw enforcement. And so while we can maybe have a slight difference of opinion about what they should or shouldn't have done to resolve this dispute, I think the bottom line, which is really clear in this order, is that if there is a suggestion that bylaws are being breached, there is a responsibility on the committee to be very thorough about that. And to be clear, bylaws are enforceable. It's not an option to do it or to not do it. It must be done. And maybe that's where things fell down in this one.
I'll just quickly jump in. And Chris, just when you were talking about it, then it reminded me of a video that we had recorded just before Christmas, and it was to do with dispute resolution. And one of the things you said in that video was that you have to remember that it's a bit different than a normal dispute, in that you see these people all the time. So if the feelings were that bad between the two people in the building, and this adjudication order's come out, certainly it wouldn't have benefited the relationship between those two lot owners, I'd imagine. So Yeah, I think we're
definitely.
looking at it from a decision point of view, but I think also that they are two people and two lot owners, and it would affect the communications within the building possibly.
Very, very much so, Nikki. It's a really good point, actually. So, William, where do we go from here in terms of hazard, do you think?
Well, that's the big question. What is a hazard? Are we now at the stage when anything that can do harm to an individual can be considered a hazard and then could be adjudicated on in a similar fashion? The obvious main issue in society at the moment is COVID. COVID is established as a hazard, obviously, in the same way that smoking is established. Does that give wider leeway perhaps in enforcing COVID orders? Can we stop perhaps people who are not vaccinated coming to meetings? We know that so far the advice has been unvaccinated people are attending meetings, but there's another interpretation where some people could say, no, I think this person is hazardous and we shouldn't let them in.
I actually think that's now on the table, William. So as you quite rightly point out, there's no question about the hazard. And just to clarify, the adjudicator had to look for a dictionary definition of hazard in this particular case. And they kind of made the point that hazard is the threat or the potential of a threat of harm from something. So I don't, is any doubt there's a potential threat from having COVID. So at the moment, if you are unvaccinated, there's no restrictions on you in using common property. I know that question gets asked a lot, but does this now open up an option to say that somebody who is unvaccinated poses a hazard? I think possibly it might. Yeah.
I think there's definitely people who would argue that. What about other issues? So, I mean, loud music's one of the main things that we hear complaints about. Loud music can be hazardous to my ears if I'm exposed to it over a long period of time. Is that a hazard?
I think what about the sleep that you lose from that? If your sleep deprivation causes other issues afterwards, and I think there's no question about the hazard of sleep deprivation. It's used as a form of torture, after all. I think that's a hazard. And then there are the physical aspects of hazard as well, William, like glass in the pool. Surely that's a hazard as well. Dog or cat droppings, refuse, that's got to be a hazard. What about a car parked up against a fire door? That's got to be a hazard, hasn't it? Yeah, I mean, the car parked against the fire door is probably in breach of the fire regulations and it should be moved automatically. But yeah, definitely all of these things there's a whole open slather here of potential cases is what we're saying. So are we expecting owners to sort of take advantage of this? Would we encourage them to, or would we more be hesitant and say, well, the smoking case was actually pretty cut and dried because, as we were saying, smoking's well established as a hazard. There's not really that much debate about it. These other issues, these other areas are much more speculative. What would we encourage people to chance their arm, or is it? Well, they can, but then that raises two issues that I think we wanted to touch upon, William. First of all, the length of time it takes. So important for everyone to remember that in this particular case, it took the better part of 12 months for the applicant to get that order from the adjudicator. So you've got to remember, in that 12-month period, that doesn't mean that the smoking just magically stopped while the outcome was on the table. Nope, it kept going and it kept going. So it possibly got even worse during that time because the parties were in dispute. So that's number one. Do you want to take that length of time? Number two, then there's the small but important issue of enforcement. So once you get an order of an adjudicator, it has to be enforced through the courts if the other party does not obey it. So you have to take your order to the magistrate's court, and you have to go to the magistrate and you have to say to the magistrate, this order is not being complied with. I want it complied with. You and I were talking about this just a moment ago, William. How do you get somebody to comply with an order that they don't smoke on their balcony? I'm actually a bit unsure of that. Do the police come around? Is that what happens ultimately? Is that what? Yeah, I mean, most people don't know. Yeah. Maybe the sheriffs have to come around and put restrictions on the entry to the balcony. Maybe somebody has to physically come and remove cigarettes and lighters from somebody's property. How else are you meant to do it?
Yeah, but it seems very difficult to stop, because then that person can simply go out and buy another packet of cigarettes, another lighter, smoke again. The police aren't going to waste, obviously, they're not going to waste their time coming around every 10 or 20 minutes to stop a person smoking. There's no financial fine here, is there? There's no financial penalty that can be enforced.
The only financial fine is there can be a penalty applied for non-compliance with an adjudicator's order, and that can actually be quite pricey, that one. There was a case a couple of years ago where somebody got fined about $10,000 for not doing that. So that possibly is where it becomes relevant. But I suppose the point is, William, isn't it? You've got to be careful what you wish for, because, okay, you've now got this option to pursue a hazard proceeding. Well and good. You will be waiting at least 12 months, if not a lot longer. You will be spending a lot of time and effort to get there without necessarily a guarantee that the hazard is going to be addressed.
No. So why does it take so long? I mean, this case actually originally started November 2020. Finally, not actually a final decision, because it might still go on to further courts. December 2021, 13 months. We're there. That's an awfully long time to pursue a case. As you have indicated, that length of time can lead to a worsening of the relationship between the parties involved. You might get things happening like, strata committees can change over that period of time. So if body corporate was leading this action, it could go from one different group to a totally different group, running at different points. Owners can sell as well. The process is taking too long is what I'm getting at here, because in the end, what we'd all rather like is a sort of, I don't know what might be acceptable, but 2 to 3 months or something like that from start to finish point sounds about reasonable. Why is it 13 months?
Yeah, I agree. It is because the Commissioner's Office just doesn't have the resources to do it more quickly than that. They are really expert at what they do. I mean, some of the most skilled, knowledgeable people in the state when it comes to strata issues work in that office. But it's one office servicing the entire state. It's not as though there's a Gold Coast office helping out Gold Coast buildings. It's one office in Brisbane for the entire state. Just so that everyone's aware of what we're talking about, there are 50,000 plus buildings in Queensland, with more and more being built every year. Every one of those buildings will have people in it who either know what they're talking about or don't know what they're talking about. And as you just indicated, William, those people turn over all the time, sell, buy, move in, move out. The knowledge level changes, the social interactions change, the ability and willingness of people to interact reasonably changes depending upon circumstances. So I suppose the point is, one office servicing the entire state's strata needs, the end result of that equation is an order that takes 12 months. What's the answer? Is it more resourcing to that office? Possibly. Is it about a different way of doing things? That's probably more the longer term outcome. What is that different way of doing things? That remains to be seen. There are a few different options there on the table. I guess the problem is more and more people are going to be buying into strata. People aren't going to be buying houses into the future. They can't afford to buy houses. More and more people are going to be buying strata. There needs to be some effort and some resource devoted to that sector, I think. What do you reckon?
Yeah, I mean, it's always going to be a combination of the answer. The solution is always going to be a combination of factors. There needs to be more resources because there's more people living in strata. It's as simple as that. You can't have the same office that you had 10 years ago, and especially like here on the Gold Coast, they're planning to build any number of buildings up and down the Gold Coast over the next 5-10 years. Well, that's going to mean more cases, more problems, and so on and so forth. Where the money for that should come from, that's open to question. Whether again, could be a tax from developers. It could be whether strata owners have to pay like a small fixed fee every year to help fund these kind of services, or whether the government simply accepts it and expands the services out. It could, again, some kind of combination of those factors. There probably also needs to be some consideration of how these matters get managed. From my perspective as a body corporate manager, I know that I see a lot of relatively minor, even petty issues go up to this higher level, where you don't really need an adjudicator to come in. We need a better mediation process, and a process with a little bit more teeth, so that an issue can be, where people could meet, discuss, and a decision can be made that hopefully people adhere to. That's a much simpler and much faster process than the current one allows for. I don't know if there's any plans to change that, but I think if that doesn't change, then the courts are just going to be swamped, and what we're going to see is this case 13 months, the next one's going to be 24 months, 36 months, or however long it goes on for, and people are just going to throw their hands up in the air in despair, because they're just not going to feel that they're supported, even when they're trying to do the right thing.
You took the words out of my mouth, William. I think all of that absolutely applies. There has to be a better way of handling, and that's not to minimise what happened here. Of course, we're not trying to minimise the impacts on people of smoking or this particular dispute. They obviously had a problem, and they needed some help in resolving it. There's got to be some better options available, and quicker options available to people, so that it does not take up the time of the courts, it does not take up the time of public servants who could be better spent doing other things as well. Nikki, I know that you had an interesting observation on all of this stuff as well in the order. We've talked a lot about the fact that the person was effectively banned from smoking on their balcony. It went a little bit further though, didn't it?
It did. When I read the actual notes on it, I was surprised to see that one of the orders made, as well as the one about not smoking on the balcony, seemed to instruct the resident on how they can smoke within their lot, which I thought was really interesting, especially for Queensland. And basically it stated the respondent may only smoke tobacco products within their lot if they take reasonable steps to stop the smoke from drifting out of the lot, for example, by closing their windows and doors. So yeah, I just thought maybe you could expand on, is it a surprising order, and why is it a surprising order, especially for Queensland?
It is, because to me, and I'd be interested to see what you think, William, to me that effectively means that person can't really smoke in their unit, period. I don't see, because how on earth can you restrict the flow of smoke? I mean, short of closing all your doors and windows and then stuffing the gaps with towels, potentially, I don't know how else you can take steps to stop smoke drifting out of your apartment. Or have I got the wrong impression there, William?
I don't know either. I mean, you can have fans and things like that, which I guess would blow the smoke in one direction or another, but it's probably almost impossible to completely limit the smoke. And then we're also talking about perhaps the smell as well here, which of course permeates through, can permeate through the walls. So is there a case here that the individual's rights have been infringed? We've mostly looked at this from the perspective of, I guess, the anti-smoking camp. But the smoking is legal within society. They're not doing anything wrong. Why can't you smoke in your unit? Why is it such a big problem? Some people are going to say, and if it causes a bit of minor disruption to others, I mean, that's just bad luck. There's lots of things that cause minor disruption to other people in body corporates, and is that just what we have to look at? I guess. Could we expect, if this case goes to further courts, that someone could overturn it on that basis of an infringement of individual rights, perhaps?
I think it's a really fair point. I mean, if I own a house on a block of land, not in the community title scheme, I've not had that restriction imposed upon me now. Nobody has told me that I can't smoke on my deck, and certainly nobody's told me I need to take reasonable steps to restrict the flow of smoke to my next door neighbour. Why is that now different to somebody in this scenario? And I guess the counter argument is always because you're in a high density situation, you're part of a community, so necessarily what you can do is restricted somewhat. But your essential point, William, remains. I bought this property. I have a right to use it within reasonable limitations. Now my property rights to do what remains a legal activity, let's not forget, no matter how much we might find smoking distasteful, it's legal. It hasn't been completely prohibited. I've now been told what I can and can't do in my property. That's a big step. And you're quite right, the balance of that against the rights of the larger group of people to not be exposed to hazard. That's effectively what this is all about. And in this particular case, the adjudicator came down on the side of the greater community. Will it survive? That's a really fascinating question. And the point remains, this is now subject to potentially an appeal, isn't it?
I think so. Is it sort of analogous to perhaps some of the way that people have looked at the Airbnb issue, where their owners have said that they have a right to lease their property because they've got a right to make money out of their property to Airbnb tenants? If I'm a landlord and I can only lease my property to someone who smokes, am I not entitled to do that to some extent? Because I've got my right to make my money off my property. And if I choose to lease it to a smoker, isn't that okay? Are we going to get a case at some point down the line where a landlord might then take action against the body corporate for infringing on their rights? If they say, well, because you've made this a no smoking building, you're limiting the pool of renters who I can access. That's we don't know the answer, of course. It's a very open-ended question, but I think that's always, these kind of things always have to be considered, and they're what make these body corporate decisions and questions so difficult to interpret, and so interesting at sometimes.
And moving forward, that's now where we're at. We've had a decision made which has created a big impression, but now we're starting to sift our way through the consequences, both real and possibly unintended as well. And now everybody who's involved in Strata, regardless of what your role is or what your interest is, now has this hanging over them. Well, do we need to think about hazard? Do we need to think about this other thing? Where does this leave us moving forward? I think where it leaves us is probably in an even more ambiguous situation than where we started, William, frankly.
Yeah, I mean, I think as a body corporate manager, I'd probably be more optimistic. I would say to my customers who are asking, we're keen to introduce some new anti-smoking legislation, perhaps anti-smoking bylaw in our site. I would be saying, well, I think you've kind of got some encouragement now that you can go ahead with this, and that you should, you can feel confident that there is some support behind it. But you also have to be conscious that you don't have the absolute solution, and that you could face challenges as well. So it depends on people's determination, perhaps, to see these things through.
Absolutely. So yeah, Nikki, I think watch this space in 2022. As the year was starting, I was thinking to myself, oh, what are we going to be pursuing this year? We'll be doing the same old legislative reform. And then out of nowhere comes this. And now this is probably the only thing that people are going to be thinking about.
So one of the other big questions that I've got, and I was just thinking about it while you were speaking, especially at the end bit, is there a chance that this will end up in the legislation?
I actually think that that's where it now sits. This is just my personal perspective, but I think the ball's back in government's court now to do something with this. They've had a decision made for them, effectively. So the issue about whether or not buildings can prohibit cigarette smoking has been on the agenda for a long time. No decision's been made about it. There's been papers, there's been options put forward. Nothing has occurred. I think the ball is very much now back with the government to do something with this one. I think the community expectation is there that something will, because the reality is at the moment, it's almost impossible for a building to have a prohibitory bylaw for smoking, but that's now changed. So is that wants to keep going with this, or do they want a bit more control back? What do you think, William?
Yeah, I think it's on governments. I think we need, I think from the government's perspective, they pretty much set their stall out where it comes to smoking. So they need to support decisions like this down the line if that's what they actually believe in. Otherwise, as I say, people will just lose faith in the system, and they won't take any individual action themselves to try to support that kind of wider decision making.
I agree. I think for what it's worth, for government to give that ability back to bodies corporate to make the decision, difficult as it might be on a contentious issue, if they properly make the decision and it passes the threshold of votes, what's wrong with that?
Yeah, because if the next thing that happens is these decisions kind of get overturned and thrown out, well, then where are we? What does anyone do next? So that, well, from the anti-smoking side, I suppose, which is what I'm on, I would hope to see that's the case, but it doesn't always happen the way that you hope.
So I reckon, Nikki, watch this space this year. I think that will be one of the legislative reform issues that will really have to be resolved in 2022.
Thank you very much, Chris and Will, both of you, for your time today. It was really great to hear the different perspectives, although there were lots of synergy between the two of you, and I think the two of you agree on lots of points, even though you were coming at it from a different perspective. So thank you so much for providing some clarity around the issue for our listeners, and we'll come back and revisit other topical issues like this in the future as well. So thank you very much.
Thanks very much, Nikki.
Thanks very much for having us on. Much appreciated.
Thank you. Bye.